The Trump administration, through the Department of Justice, has once again shown their desire to make sure that the Second Amendment is not considered a second-class right. Last week, the Department of Justice entered into a settlement agreement with Rare Breed Triggers, who are the makers of the force reset trigger FRT 15. This is obviously great news for the 2A community, but those residing in the Sunshine State, well, you're not going to get to partake in this celebration. Be sure to stay tuned as we discuss the terms of the settlement agreement and why it sucks for those who reside in the state of Florida that want to purchase an FRT. Hello everyone, and welcome to the Firearm Firm channel. I'm your host, James Phillips, a practicing Second Amendment lawyer and co-author of Florida Gun Law, Armed and Educated. Last week, Pam Bondi's Department of Justice entered into a settlement agreement with Rare Breed Triggers, bringing an end to various litigation Rare Breed Triggers had to suffer through under the Biden administration. I did a video about 2 years ago titled, "Is the ATF Coming For You?" in which I discussed the ATF's attack on Rare Breed Triggers and their force reset trigger. In that video, I also discussed what force reset triggers are and how the ATF decided to exceed their authority and classify these triggers as machine guns. Over the last couple of years, ATF has reached out to those individuals that they believed own FRTs, and they requested those individuals to voluntarily surrender them to them. Well, about 3 months ago, I received several notices from the ATF wanting to return some FRTs that some of my firm's clients had given to us to anonymously surrender to the ATF. You can check that video out by clicking on the link above. For those of you who are watching and not really familiar with the legal controversy surrounding force reset triggers, the Department of Justice filed a federal civil lawsuit against Rare Breed Triggers, the makers of the FRT 15 in the state of New York, seeking to prevent the production and sale of the FRT 15, claiming they make firearms into machine guns. Besides the federal civil lawsuit in New York, there are other pending lawsuits regarding Rare Breed Triggers and FRTs, including National Association of Gun Rights versus Bondi, which the government had appealed after a federal district court in the Northern District of Texas had ruled against them. Also, there is, or I should now say was, the United States versus miscellaneous firearm and related parts and equipment listed in Exhibit A out of Utah, which involved Rare Breed Triggers. The settlement agreement the parties entered into resolves all three of these cases. Now, Rare Breed Triggers did have other litigation, including a case in the Middle District of Florida, but at the time the settlement agreement was reached, there was only the three cases I just mentioned. Now, as part of the settlement agreement, the government has agreed to dismiss the appeal that is pending before the Fifth Circuit Court of Appeals and to dismiss with prejudice the Utah case. Rare Breed Triggers also now had to make some concessions in the settlement agreement, including agreeing not to develop an FRT for use in handguns. They also agreed that they will not market, advertise, or encourage individuals to put FRT triggers on any handgun. And they would also agree to take all reasonable efforts to engage in patent enforcement, seeking prohibitory injunctions against any person or entity that manufactures, sells, or distributes any FRT during the life of their U.S. patent. I will attach a copy of the settlement agreement down in the description section for anyone wanting to read it. Now for the bad news. Although FRTs are legal to have and possess under federal law, those residing in the state of Florida are still not going to be able to legally possess them. As I've discussed in other videos, Florida Statute 790.222, titled Bump Fire Stocks Prohibited, makes it a felony to import into this state or transfer, distribute, sell, keep for sale, offer for sale, possess, or give to another person a bump fire stock. Under this statute, the term bump fire stock means a conversion kit, a tool, an accessory, or a device used to alter the rate of fire of a firearm to mimic automatic weapon fire, or which is used to increase the rate of fire to a faster rate than is possible for a person to fire such semi-automatic firearm unassisted by a kit, a tool, an accessory, or a device. Well, there's no question an FRT allows a semi-automatic firearm to fire at a rate faster than it would without an FRT installed in it. Sorry, fellow Floridians, but installing an FRT is not in your near future, or at least not if you want to remain on the right side of the law, which of course I advise doing. Be sure to let us know what you think about this settlement agreement down in the comments section, and also let us know if you agree with me that Florida Statute 790.222 needs to be repealed. Until next time, stay armed and educated.